This meeting is being recorded.
Hi, and welcome to Bickhram Litigation's first vlog. My name is Rick Bickhram.
Hi, I'm Sabrina Aujla, and I'm Rick Bickram's articling student. So welcome to our first vlog. Our whole purpose of doing these vlogs is to teach you guys about different legal concepts and answer any questions you guys may have.
Sounds like a really cool concept. Sabrina, what are we talking about today?
So today we're going to discuss if you can force the sale of properties.
All right. And have you read any decisions recently that you can probably share with our viewers today to help us understand when we can, or when a joint tenant or a person who has a financial interest in real property may be able to compel the sale of a property?
Yep, so I actually came across Davis and Davis, which is still a binding case from 1954. So essentially what happened in that case was there was a married couple and they were residing in the home. So it would be considered their matrimonial home, and the husband was quite abusive. So eventually the beatings got so bad that the wife fled. She left the property, she left their children there, and during her divorce proceedings, what happened was that the husband got full custody of the children because they were, one, already living with him, and two, there was really no evidence to show that they were in any harm or anything like that. So during the proceedings, the wife essentially said, hey, this is my property as well. We hold it in joint tenancy and I want to sell it now.
And you think inherently, like she picked up her personal belongings, took off. She had a financial interest in that property, in that house. She left it all back there. So she's pretty much saying to the court, she's applying to the court and saying, hey, I need money, I need to live, I need somewhere to have shelter over my head, someplace to sleep at night. So she commences the application. She's asking for the sale of the property. And if I understand correctly, there's three principles essentially that the court ruled on here where the court would have jurisdiction to sell the property. And the first principle is that a joint tenant has a prima facie right to the sale of the property. The second principle is that the other joint tenant has a corresponding obligation to agree to the sale of the property. The third point is that the court should always award the sale of a property unless there is sufficient reasons not to do so. And the third point is really interesting here, I find, Sabrina, because in the third point, the court doesn't elaborate on it. In fact, I think the court actually says every case is unique. It's based on its own factual circumstances where the court would or would not award it. And there's a subsequent Court of Appeal decision, and that's in the Silva decision, Silva v. Silva. And all of these decisions will have sites at them at the bottom of this video afterwards for you guys. But in that Silva v. Silva decision, if I understand correctly, the courts go on to elaborate when sufficient reasons or circumstances may exist where the court will not grant the sale of the property. And if my understanding is correct, the court says that if there's malicious conduct, vexatious behavior, or if there's oppression, the court will not grant or force the sale of the property. So I turn to you, Sabrina. What do they mean by malicious conduct? What does malice mean in the eyes of the court in situations where someone's trying to sell their house, force the sale of property?
Yep, so essentially what malice is it arises when the proceeding is brought for an improper purpose. So essentially you're bringing forward the application. It's not what the application is doing, I guess, but it's why you brought the application forward. So you're doing it out of spite, out of vengeance, or to gain some sort of collateral advantage. And you're just essentially bringing it to bring it. There's no real purpose to it.
Yeah, sometimes individuals will bring proceedings to gain some sort of litigation advantage in existing litigation, and the courts are pretty much saying, hey, we're not going to award in this situation because it's patently unfair. The second concept was vexatious, and vexatious behavior exists where there may be a multiplicity of proceedings that are commenced, or a party just wants to relitigate an issue, right? They may frame it differently, and a court has decided upon it previously. Despite reframing it, it's still the same issue that was decided before. So that's vexatious behavior. And in circumstances where the courts feel it's vexatious, the courts will not award or force the sale of real property. And the third point, I believe, was oppressive conduct. Sabrina, could you elaborate a little bit on the oppressive conduct part for us?
Yep, so that one I find actually pretty interesting. So oppressive conduct was defined as The co-tenant opposing the sale will suffer hardship if the property is sold. So you can see that things that's like financial hardship or undue hardship. So I don't know if you've read the case Arlow and Arlow, Rick, but that one was quite interesting because it goes into undue hardship. So what we're talking about there is essentially a husband and wife. They're going through divorce proceedings, and the husband wants to sell the house that they own on joint tenancy. But there where it gets a little tricky is that they both have the same income. So if they sold the house, if they didn't sell the house, nobody would have the advantage. They'd both essentially be on the same level. So that would be, considered, that's looked at when we're looking at oppression.
I did read the decision, and in that case, if I recall correctly, Mrs. Arlow was residing in the property. Mr. Arlow had left the property, and it was Miss Arlow who was saying she couldn't leave the property. She had nowhere to live. She made, at that time, it's an old case, so at that time she was making, I think, about $25,000 per annum. And she said, hey, if you force the sale of this property, I have nowhere to live. And the courts held in that decision that mere inconvenience or finding it difficult is not enough for the court to hold up the sale of the property, right? So it was a really good decision, interesting decision. I recommend everybody read it. I will have the citations for these decisions at the bottom of the vlog. Thank you guys for watching our vlog. We will be back on in about 2 weeks with episode 2. This has been fun. Rick Bickhram signing off. Until next time.
Thanks for joining. And please let us know if there's any concepts you'd like us to go over, and we'll definitely include it going forward. Thank you.